All right, so we'll continue with our discussion on latest cases. So today we have 3 cases of the Supreme Court of India. 2 are related to corruption and another one is related to a right. So we will continue with that discussion. Now, first one, as you can see, it is related to corruption. Okay, corruption is a crime against society. So mostly, right, when you talk about this difference between civil and criminal wrongs, in case of crime, we ideally consider it as a crime against the society, right? In case of civil suits, it's like affecting the individual parties. That's why we would see the party's name in the case, right? It's like you versus me or someone versus the other. But, or it may be like one company versus the other company. But in case of crimes, we mostly see state being a party. Why? Because we say that it is a crime not just against the person who is a victim, but it is a crime against the entire society. Let's take, for example, this case we were discussing last class, Rama versus Ramesh, because it is a civil matter, right? It may be some builder versus one person, because these are civil matters wherein it's not that serious, one person versus another person. It may be one company versus another company, or it might be one company versus another person as well. Like that, we would see cases. But in case of criminal matters, it is considered as a crime against society. So same ways, in this case also, Supreme Court said corruption is a very serious crime and it's a crime against the society. It was decided in 2021 only. The case name is State of Gujarat versus Balchandra Lakshmi Shankar Dave. Okay, so this was decided by Supreme Court of India and it was decided by two judges, like a division bench of judges. Okay, now what happened in this particular case is that the respondent of this particular case, okay, this person who is the respondent in this particular case, he was the original accused in the original case which was filed before trial court. He was the accused, and in this case he is the respondent. He was working as assistant director in ITI Gandhinagar. Okay, this case is from Gujarat, so he was working as assistant director in ITI Gandhinagar, and he was charged for the offenses punishable under Prevention of Corruption Act. So there were charges of corruption against this person who was working as assistant director in ITI Gandhinagar. Now, when this case was filed in the trial court, special judge, after full-fledged trial, all right, after following all the stages of trial and after appreciation of entire evidence on record, right, whatever evidences were produced, all those evidences were seen, full-fledged trial happened, all the stages happened, and by detailed judgment and order convicted the accused. All right, now you must be knowing that when a certain judgment is given, even though this person is a judge, does not matter. The person simply would not say that, okay, this is the punishment that I'm giving. Okay, when you read a certain judgment, you would always see that in the judgment also, right, the person would try to justify the reason why this certain judgment is being given. Okay, like we have this concept of precedent in India. Anyone, what is precedent? What is a precedent? Example set by previous judgment. Correct. So whatever is already being decided, try to follow that. If that is not like given by mistake or something, we should try to follow that. Now, when we are following a previously given decision or the precedent, right, judgment becomes very important. What is written in the judgment, that becomes very important. Now, in a judgment, there are basically two different parts. Okay, one judgment contains two different parts. One is called ratio decidendi, which means reason for the decision. What is the reason for which judge has given this decision? That is one part which is very important, that is taken into consideration while following this rule of precedent, that this reason or the rationale has to be followed. Okay, and apart from that, there is something called as obiter dicta. Obiter dicta is nothing but like an opinion which is given by the judge. All right, like judge may say that, okay, fine, in this certain case, legislature should like take up the matter, they should take action. Like you would see there are too many cases wherein Supreme Court has observed, okay, by way of obiter dicta, Supreme Court has given their opinion that maybe it is high time that the legislature prepares a law relating to witness protection. Okay, it is high time for the legislature to prepare a law specifically dedicated to witness protection. So this is nothing but obiter dicta. Okay, sometimes court may see that, okay, for this certain provision, we have the facility of providing compensation, but this compensation amount is very less. Maybe it's time that we should increase the amount. They might say that maybe it's time for the, you can say, Law Commission of India. Okay, for Law Commission of India to do a detailed research on this certain area. All right, so there may be different opinions which you would see in a judgment, and this is what becomes very important over there. Like obiter dicta is also very like important, but it's not having like this precedent. In terms of precedent, it's not that relevant. Otherwise, we can say that, okay, Supreme Court was of this view and sort of things we can mention. Now, what happened in this case is the trial court judge, right, they conducted this full-fledged trial, whatever evidences were recorded, everything they have seen. Okay, and they gave a judgment and convicted the accused under the act. Now, what judgment was given? It was detailed judgment and order. Like I said, they would give reason for the decision, right? How reason would be given? They would maybe give citation of 2-3 cases. They would maybe say that we, like, while following this rule of precedent, right, in so and so case, so and so court has said this, in this court this has said this, as per this law this is what it is, right? Like that, they would try to justify the reason. They would simply not say that, okay, this is the decision, take it, but they would try to justify the decision. So in this case, what happened is, trial court judge, he conducted a full-fledged trial. He appreciated this entire evidences which were there, recorded, and detailed judgment and order was given, convicted the accused under the act. Okay, the order convicted the accused. Now, learned special judge held the accused guilty and convicted the accused, and he gave him this punishment of 5 years of imprisonment. Okay, 5 years of imprisonment plus 10,000 rupees fine he has to pay. Now, in this entire situation, right, trial court judge has properly justified it, given the judgment, everything is there, right? It's like a proper decision which is there. Now, as a judge of this certain court where the case is filed, like we say like learned judge, and in this court the case was filed. So here's learned special judge. Okay. Now, when this judgment came and this person was convicted, like he was found guilty of provisions under Prevention of Corruption Act, he was not satisfied with this decision. Now, when he was given this punishment, right, the person was not satisfied, like this assistant director was not satisfied. So feeling aggrieved and dissatisfied with this judgment and order of conviction and sentence which was passed by the judge, the accused preferred an appeal before the High Court. So because he was not satisfied, with the trial court decision, giving him 5 years of imprisonment plus 10,000 rupees fine, he approached High Court of Gujarat by way of criminal appeal number this. So if you are willing to read the High Court case also, you can simply go to High Court website, put this number and get access to it. Actually, it happened like in lower court, it happened. After that, it went to High Court. After that, when it went to Supreme Court. So it's technically it's 3 cases, but yeah, the matter took these many years. You are correct on that point. The matter took 18 years to be decided, but technically there are 3 cases involved, right? Trial court, High Court, and then Supreme Court in 2021. Right? Sometimes you would even see some cases pending for like 10-20 years also. So like that also it happens. Nothing to be surprised actually. So because it went to High Court and High Court gave a certain decision. So this was the case number. If you want, you can see this as well. Criminal Appeal number 92, 2003. Now, the High Court, without any detailed reappreciation of the entire evidence on record, has acquitted the accused for the offenses for which he was convicted. When it was before the trial court, they had done proper, like a full-fledged trial, saw all the evidences, with proper reasons they gave the judgment. Everything was done properly. But when it came to High Court, they did not even see what were the evidences that were submitted. They simply acquitted the accused. They simply said that no, he is not found guilty. This is acquitted for the offense for which he was convicted. Like they basically altered the entire judgment given by the trial court. So first at this stage, what happened? It happened in the trial court, the person was given punishment, right? Assistant director was given punishment, 5 years of imprisonment and 10,000 rupees fine. So the accused was not happy with it, right? The assistant director was not happy with it and he went to the High Court. Now High Court said, no, this person is not guilty. We are acquitting him. They altered the decision given by trial court, right? Now in this stage, what happens is, state of Gujarat was not happy. Okay, so feeling aggrieved and dissatisfied with this impound judgment and order of acquittal, which was passed by High Court of Gujarat, state of Gujarat has preferred the present appeal before Supreme Court of India. Right? Because it is a crime against the state and state would always be a party in such cases. So state of Gujarat was aggrieved by this decision, which was given by High Court. So they decided to file an appeal before the Supreme Court of India. So when this matter was filed before Supreme Court of India, then Supreme Court of India, what was their observation? We will see. Supreme Court of India said that the High Court ought to have appreciated that it was dealing with first appeal against the order of conviction, which was passed by the trial court where the case was initially filed, right? So they are the first appellate court where parties would go just after the trial court, where the parties would go. So being the first appellate court, High Court was required to reappreciate the entire evidence on record. Okay, and also the reasoning given by learned trial court while convicting the accused person. Whatever evidences were given, are those proper or not, they should have seen that. Plus, what is the reasoning given? Like as here it is mentioned, right? Trial court gave proper reasoning, proper ratio they had given. So those reasoning should have been seen by the High Court. Why is the person accused? Why is this 5 years of imprisonment and 10,000 rupees fine given? Okay, but what happened is, no reappreciation of evidence on record may affect the case of either the prosecution or even the accused. When evidences are not being seen, where these grounds given by the trial court are not being seen properly, it may affect the case as well, right? It may completely change the decision. Yeah, first appellate court is High Court. For some cases, it's like if magistrate court it is being filed, parties would go to sessions court. But concerning this one, right, in this case, because for prevention of corruption, matters would go straight away to the sessions court. So High Court becomes like the first appellate court. It actually depends where the case is first filed. Okay, like for check bounce and other, you would see first appellate court would be sessions court because cases filed in magistrate court. It differs from case to case. Okay, and in fact, there is one very useful thing that you can see. Okay, in your free time, you can go to this CRPC Barrett. You can simply type first schedule. Okay, go to the schedule, and here you would see by what court cases are triable. Like this is like an entire list provided for crimes which are mentioned under IPC. So you get to know whether the case would go before sessions court, magistrate court, which court it would go. And for other cases, right, it's usually maybe mentioned in the legislation itself. Like take for example, if you talk about section 42 of NI Act, which is relating to your check bounce, right? There it would say no court inferior to that of metropolitan magistrate or a magistrate of first class will try it. That means for check bounce, you need to go to a magistrate court only. Like that in the legislation also, sometimes it may be specified which is the right court that is there. So next level court would be like the appellate court, okay? So in this case, the Supreme Court was of the opinion that because you are like the first appellate court, you should have at least seen what all evidences are being given and all the things you should have seen. What are the reasons given by the trial court, all that thing you should have seen, wherein you failed to do that. Okay, because it would completely like alter the case and everything. Honorable Supreme Court found that High Court decision is totally based on erroneous view of law. The approach of High Court in dealing or non-dealing with evidence was patently illegal, leading to grave miscarriage of justice, just because they failed to see all the evidences what were given, right? Like what were the conclusions made by the trial court. They should have at least invested some time in seeing that. Just because they have not done it, it has caused huge error, and that may lead to miscarriage of justice also. Therefore, we are of the firm opinion that this impound judgment or order which is passed by High Court, like in this case, right, as compared to the previous cases that we have decided, I tried to put like extractions from the original judgment itself so that you get to know how like things are written in a judgment itself. Okay, so this you would see language of the court over here. So Supreme Court basically said that we are of this opinion that this order which was passed by High Court in acquitting this assistant director, right, without adverting to reasons given by the learned trial court while convicting the accused, and without reappreciating the entire evidence on record in detail, cannot be sustained, and the same deserves to be quashed and set aside. Okay, so High Court said that whatever decision, like Supreme Court said, High Court, whatever decision is given by High Court, that is not proper. And because they have failed to look at the grounds which the trial court has said and all the points which they have mentioned, right? So this order that the High Court has passed, it deserves to be questioned. It is not valid. We are setting this aside. Okay, this order will not be bound. It would not be valid or binding. Plus, they also said that again and again, they are saying this thing that High Court should have appreciated that they are dealing with like a serious case, which is nothing but coming under Prevention of Corruption Act, right? And they should have been more careful while giving the judgment. They should have looked at the details as well. Okay, so we do not approve the manner in which High Court has dealt with this particular appeal which was filed before them. Plus, they also said that this order or judgment dated 12/1/2015, which was given by the High Court, right, based on Criminal Appeal 92/2003, acquitting the accused for offences under Prevention of Corruption Act, for which he was tried, is hereby quashed and set aside. So they have clearly said that this order that High Court has passed, we do not accept that certain order and we are setting this order aside. It is not binding. It is not applicable to the parties. Plus, they also said that the appeal before High Court, like Supreme Court has just given their opinion. Okay, they have just given their opinion that how High Court should have dealt with the matter. Supreme Court has as such not given a decision based on this matter, but what they said is the appeal before High Court is restored to its original file. As in, High Court was negligent in giving a decision in this case, so we do not accept what order they have passed on 12/1/2050. We have quashed it, we are setting it aside. Plus, we ask the High Court to restore this appeal which was being filed, and High Court need to decide and dispose of the appeal in accordance with law and on its own merit, bearing in mind the observations made here. That means they should keep in mind that they are dealing with a very serious matter, case falling under Prevention of Corruption Act, and these are serious matters. It is a crime committed against the society. So keeping all these things in mind, taking into consideration the evidences, taking into consideration the observations made by trial court, the reasoning given by trial court, they need to again entertain this appeal. Okay, the previous decision is not valid, not binding. At the cost of repetition, we observe that we have not expressed anything on merit in favor of either the prosecution or the accused, and the High Court to decide and dispose of the appeal on its own merit. That means when we are making all these observations, we are not speaking either in favor of like the state of Gujarat or either in favor of the assistant director. We are neutral. What we are saying is High Court should have been more careful while dealing with the matter. Okay, so we are not saying that assistant director is actually guilty, or we are not saying that he is not guilty, but that decision has to be taken by the High Court. But we are just like giving a direction on how it has to be done. Okay, so based on the observation of Supreme Court, it cannot be said that the person is guilty or not. It is a call that High Court has to take based on its own merits. Whatever evidences are there, other records, all those things need to be seen, and based on that, they would give the decision. Okay, is it clear?
So the case is still going on in the High Court?
Yes.
Okay.
And most of the times we get details of it. So you can see name of the case. Sometimes for some high courts, I guess for Patna, with party's name also you get details of case. But for most of the other high courts, we need at least the case number, year, and type of case as well. Okay. Right. Next case we have, again, this is relating to prevention of corruption only. Okay, and in these all three cases, right, I have just tried to put some important paragraphs from the judgment so that you have an idea on what the court has written. Okay, so this case is N. Vijay Kumar versus State of Tamil Nadu. This was also decided in the year 2021, that talks about demand for or acceptance of bribe as a crime, or you can say demand for or acceptance of bribe needs to be proved in order to prove the person guilty under this legislation, Prevention of Corruption Act. So we would see this case. Again, this was decided by Supreme Court, Vijay Kumar versus State of Tamil Nadu. So in this case, decision was given in 2021 by a 3-judges bench of the Supreme Court, and all the 3 judges agreed to the same point. Okay, and they stated that this is very important: mere recovery, okay, mere possession or recovery of currency notes is not sufficient to constitute such offense of bribery. Just because someone is having possession of currency notes, that in itself does not indicate that it is a case of corruption or it is a case of bribery. What has to be proved along with that? Demand for an acceptance of bribe has to be proved. That means just having possession of currency notes is not enough. Along with that, you need to have some other evidences proving that the person has actually demanded for bribe and the person has actually taken it also. That you need to prove. Like either of it, you need to prove. Presumption under Prevention of Corruption Act can be drawn only after demand for an acceptance of illegal gratification is proved, which is very important. And it's not just this case which was decided in 2021. In fact, before that also we had cases wherein the same thing is being mentioned. And in fact, if you open this judgment, right, in Supreme Court, this India Kanun website, you will see they have given reference of other previous cases also, like this rule of precedent again applied there, wherein they said that yes, in so and so case also, court has already mentioned it, that you either prove that the person has demanded for bribe or person has taken bribe. Simply having possession of currency note is not enough. It is also fairly well settled that the initial presumption of innocence in the criminal jurisprudence gets doubled by acquittal recorded by the trial court. So what is initial presumption of innocence? Anyone?
And you are innocent till proven guilty.
Yes, you are innocent until proven guilty. Everyone is innocent until proven guilty. Correct. So that's why we say the person is an accused, not a criminal. So initially in criminal jurisprudence, initially the person is presumed innocent. Fine. But this presumption gets doubled by acquittal recorded by trial court, because in trial court they would do this entire trial thing, right? All the witnesses, everything, evidences, everything would be seen. After that, if trial court has like acquitted the person, it adds on to this initial concept of presumption of innocence, right? It adds on to that even after seeing the evidences and all the other stuff, trial court has concluded that the person is innocent. So that sort of adds on to this initial point. So the appellant sole accused was working as sanitary inspector in Madurai Municipal Corporation. So he was working there as a sanitary inspector, and those people would have like a lot of powers with regard to sort of condoning delay and stuff. Okay, if there is some delay from some vendors or from some other dealers and stuff, right, they can allow, they can disallow, and all the stuff can happen. So what happened is this sanitary inspector has filed appeals in the case aggrieved by the conviction recorded and sentence imposed by Madurai bench of Madras High Court through judgment and order dated 2020 and September 2020 under Section 7. So it's again related to Prevention of Corruption Act, wherein it was said that he has demanded an amount of 500 rupees plus a cell phone as illegal gratification from a person who was working as supervisor in a voluntary service organization called Neat and Clean Service Squad. Like they were working under this municipal corporation. So there was some sort of delay from their side and they wanted like an extension. Okay, and for that extension, like this person, supervisor approached this sanitary inspector in Madurai Municipal Corporation, and then he said that from this person, right, D. Gopal, sanitary inspector had asked for illegal gratification, 500 rupees plus a cell phone. When D. Gopal had approached him, he had demanded for it and as a motive exercise official function. So the case was filed under Prevention of Corruption Act. On denial of charges were framed against him and he had pleaded not guilty. When the matter went to trial court, he was asked, do you plead guilty or not? He said, I do not plead guilty, and the entire trial process went. Therefore, it was tried before the special court. After considering the oral and documentary evidences on record, trial court acquitted the appellant. Okay, this is very important. That's why they are saying that when a person is acquitted, it adds on to this initial presumption. Because after seeing the evidences, after seeing all the, like oral and documentary evidences, trial court concluded that this person is acquitted. Aggrieved by this judgment, state government preferred criminal appeal before the High Court, which through the impound judgment reversed the acquittal and convicted this person. So when appeal was filed in the Madras High Court, in their Madurai bench gave an order whereby they said that this person is found guilty and he was given punishment, rigorous imprisonment of 1 year and penalty of 5,000 rupees. Okay, so basically they changed the decision which was given by the trial court. Now, in this case, when the matter was filed before Supreme Court, because the person was not happy with it, right? The sanitary inspector was not happy with it, so he filed a case in the court, Supreme Court. Now, Supreme Court said that once conviction is recorded under Prevention of Corruption Act, it is because it is like a serious crime, right? There is always this social stigma that get attached to the person that yes, maybe while doing his work, while providing the public service, this person has done something wrong. He is taking bribe or he is demanding for bribe. Okay, so from the society, the serious consequence would always be there. People would feel like, okay, fine, maybe this person is taking bribe. Okay, the social stigma is there because it is a serious crime. The trial court has disbelieved witnesses by recording several valid and cognate reasons. Now, when we talk about this oral and documentary evidences, the witnesses, when those evidences were produced, when witnesses gave their point, if the trial court is not accepting it, right, they would even mention the reasons. Okay, so trial court may mention the reasons. Even like when a person is acquitted, right, court would mention that this person is acquitted because his guilt is not proved. Or sometimes it may be written that this person is acquitted because there is benefit of doubt. He is getting benefit of doubt. Like we are completely, like we are not 100% sure that this person only has committed the crime. That's why only we are releasing, but there might be a possibility that he has committed a crime. Like if any one of you remember, we had discussed one case as well. A person was selected for this constable post in UP, and then there was a case registered against him. The judgment came and then he was like, I was acquitted. Why are you not offering me the job? But then the police department said that no, you cannot be offered this job because you were acquitted on the ground of this benefit of doubt only. Like the court was not 100% sure that you are only guilty. That's why you are acquitted. It's not like you are, like court is also sure that you are not, right? So those details would usually be mentioned in the judgment, which becomes very much important and very much relevant. Okay, so in this case also, trial court acquitted the appellant, right? Trial court said that he is not guilty. And while doing that, trial court has mentioned valid reasons that, okay, fine, there were witnesses, but why we are not believing on their point? Why even after providing evidences, we are not believing on this point? Those records were properly mentioned by the trial court in their judgment while acquitting the person. But on the other hand, High Court, without appreciating evidence in proper perspective, has reversed the view of trial court. High Court said that no, this person is guilty. This is the punishment. This is what the person has to suffer. Okay, High Court simply gave this order without looking at the evidences. But as if we compare the trial court, they have properly seen all the evidences and everything. Yes. The Love Kushmina case, benefit of doubt case, correct, where it was said, right, even if you are acquitted based on benefit of doubt ground only. So like that it may happen. Like, so what happened is, in view of material contradiction, the prosecution has not proved the case beyond reasonable doubt to convict the appellant. Why are you even convicting this person? You need to give reasons. You need to give proper grounds, like we have mentioned. In a judgment, there are two parts, right? Obiter, dicta, and ratio decidendi. It does not matter you are a judge of high court or what, you need to give a reason for that. So in this case, for conviction, reasons were not given. But on the other hand, trial court has mentioned it very clearly, very properly, mentioning all the grounds and reasons. It is equally well settled that mere recovery by itself cannot prove the charge of prosecution against the accused. Just because you have got these currency notes, that does not in itself prove the point of the person. But what you need to prove in addition to this recovery is, you need to prove by some point either claim or demand of bribe or acceptance of bribe, that you need to prove. Okay, so the court was hence of the view that the demand for an acceptance of bribe amount and cell phone by the appellant is not proved beyond reasonable doubt. Just recovery does not prove the entire case. You need to give some additional information also. Having regard to such evidence on record, the acquittal recorded by trial court is a positive view. As such, the judgment of high court is fit to be set aside. So in the previous case, what happened? Supreme Court said that high court has just, like dealt with the matter in a very casual way. They need to look into this again, because we are not concluding who is right, who is wrong. Might be trial court has given the decision wrongfully, but high court need to give proper reasoning. Okay, but in this case, because trial court had already mentioned all the reasons that this is why we are not accepting the witnesses, evidences and everything. So Supreme Court came to the conclusion that yes, trial court has done their job properly. High court has only just simply altered the decision without any sort of valid ground or reason. So what we are doing is, we are setting aside this order that is passed by the high court, and trial court's viewpoint we are accepting. So whatever acquittal order was passed by trial court, that only would be valid, that only would be binding. But this decision given by high court will not be binding. Okay, so that means in this case, this person, the sanitary inspector, owned the case versus state of Tamil Nadu. In this particular case, it has to be decided by High Court of Gujarat one more time, taking into consideration all the evidences, materials, and all the things available with them. Okay, are these two cases clear? Both are related to corruption.
Yes, ma'am.
Okay. So let's discuss something else, which is relating to right to choose life partner. Okay, this is an interesting case that we will see. This again of 2021 only, Lakshmi Bai versus state of Karnataka. Okay. This was also filed in the Supreme Court of India as a writ petition. Now, what happened in this case? Mr. Basappa, who is, so this, it's like a bride and a groom. Okay, so we are talking about this bride now. Bride's father, okay, Mr. Basappa, reported his daughter, Miss Lakshmi Bai, in the present case, to be missing since 14th of October 2020. Okay, so this bride, Lakshmi Bai, she was missing from her home, and the father, Mr. Basappa, filed a missing complaint in the police station. Okay, on 14th of October, he went to the police station and he said that my daughter is missing. In response to this missing complaint, a missing person's first information report was also filed. So the person took up the matter, which was informed by the father, and the investigate, the officer in charge, she filed an FIR, and the investigating officer gathered the missing person's parents and relatives statement as well as their phone number. So once an FIR is being filed, they would do the preliminary investigation, right? So they did this investigation. For that, definitely they would take statement from parents, relatives, friends, and other, right? Like, where did you see her last time? What did she say? What was she wearing? All that stuff they would ask, right? So apart from that, statement as well as their phone numbers were taken. After accessing the call details, it was evident that Lakshmi Bai was in contact with Santosh Singh Yadav. Okay, so she was talking to this person. Now, in the it is pertinent to mention that both of the parties were well educated. So both these bride and the groom, Lakshmi Bai and Santosh, both of them were well educated. The groom had completed his MTech, girl had completed her MA and B.Ed, and she was working in Sham's school. Okay, she was a lecturer, and the groom was also working in some college as an assistant professor. Okay, so both of them had completed their education, they were doing good. Now, during the stage when they were involved in these two colleges in their teaching assignments, they both came in contact with each other, and then they fell in love during this assignment. Now, during the course of investigation to find Lakshmi Bai, it was also discovered that she and this person, right, Santosh, like the bride and the groom, they both traveled from Hubli to Bangalore, and then they went to Delhi through Bangalore without informing her parents. That is why the father filed this complaint, right? Missing complaint was filed, and then FIR was lodged. So it came to know that this girl, along with the groom, they both went to Delhi, and there they got married. Okay, without informing parents, they got married. And one day later, on 14th, she went missing. On 15th, they got married, and they just informed about it via WhatsApp. She just shared this marriage certificate with her parents. Okay, she informed that we got married. Now, considering that a missing complaint was filed, already the parents came to know, right, that she was not missing, but she got married to a person. But because this missing complaint was already filed, investigating officer had the obligation, right? He had to close the matter. Whether the person was missing or not, whether the person is found or not, he also had the responsibility of closing it. Now, what happened here is, considering that a missing complaint was filed, the investigating officer went to Ghaziabad, where plaintiff petitioner one, that is Lakshmi Bai, resided, and demanded that Lakshmi Bai appear at this police station, right, where the father had approached. In this police station, she should be going, okay, to provide a statement that she was married so that the case might be concluded. So he told her that because this case is pending, it is pending before me, I need to close it. You need to come to the police station and you need to provide a statement that you are not missing, but with your own interest, you have got married, so that I can conclude this case. Now, this was also followed by a letter written by petitioner number one to the investigating officer. Lakshmi Bai was already scared from her parents, right? That's why she escaped and then got married. Through WhatsApp, she had shared the marriage certificate. So what she did is, when the investigating officer claimed that you need to come, you need to give a statement, she wrote a letter to the investigating officer and indicating that she was married to Santosh, and that due to imminent threat from her family members, she was unable to visit the police station. Like, some uncle of hers was also threatening and other things, so she was scared to go to the police station because it would be in the same place where her parents are there. So she just wrote a letter informing that I got married, I cannot travel there because of threat. But what this investigating officer did is, he refused to close this case. In fact, he told Lakshmi Bai that unless you return to Karnataka and you give your statement, okay, what we will do is we will file a kidnapping case against your husband. All right, against your Santosh, husband Santosh, we will file a kidnapping case that she has kidnapped you. And your family members has requested for it, so I will do that. So you need to come to Karnataka, you need to give your statement so that I can close the case. Even after she wrote a letter and informed about it. All right, now what happened over here is, because she was scared of all this situation that was happening and her right was being violated, she decided to approach the court and she filed a writ petition saying that my right is being violated. She claimed that she was subject to dual jurisdiction because she lived with Santosh in UP while she was from Karnataka. So the petitioner filed the case and said that my uncle is also threatening me, so I'm scared to go there to provide my statement. So she even sought for protection from Allahabad High Court, but the petition could not reach the board on an urgent hearing. Like, this matter was not taken up urgently, even though it was a serious concern of threat or the person was scared. So now the main issue was when she went to the Supreme Court and informed about the matter that this investigating officer is threatening me for this certain things, and he is also saying that like a kidnapping case will be filed against my husband. Right. So the main issue was whether the first information report should be quashed because both the parties consented to marry at their own will. It was very much clear that it is not like a missing case, right? She was not missing from her house, but she rather confessed the entire story. So is it that this FIR should be quashed or not? That was the main question, because there is no point doing further investigation on this point. And usually you would see, right, this quashing of petition FIR, that is like a very common thing that happens. Sometimes like a fake FIR may be filed and party would approach the High Court and say that this FIR needs to be quashed because it is like a fake grounds, on fake grounds this is being filed. Sometimes for judgments also, some orders also, it may be filed that this certain order is not proper, you need to consider it invalid. Okay, so cases would be filed. It is usually filed under section 482 of CRPC. It's like inherent power of High Court. High Court has the power to take up such matters. All right. So in this case, what happened is Supreme Court ruled that the procedures arising from this police station where the first information report was filed, this is not valid. Okay, so what was the view of Supreme Court on the approach that the investigating officer was taking, that you need to appear and you need to provide your statement so that I'm able to sort of close the case, right? So what was Supreme Court's view in this case? So Supreme Court was not very happy with the way investigating officer handled this investigation. It stated that investigating officer could have visited residence of petitioner. Number two, that is like the Santosh, husband's house, he should have visited. He could have recorded statement of the petitioner at the place where petitioner was residing, rather than insisting and calling upon petitioners to come to local police station at Karnataka, thereby delaying the investigation. So the purpose or the point for investigating officer was to record the statement, right? He just needed the statement of the petitioner. So rather than calling this petitioner to Karnataka, wherein she has in writing informed that there is risk, she cannot travel there, he should have traveled and he should have recorded the information, right? He should have taken it in writing and he should have closed the matter, rather than calling her and threatening her to give her statement. Otherwise, like, he would file a case. Moreover, the investigating officers moved to threaten the petitioner with false charges on her husband if she did not come to Karnataka to give a statement, was seriously disregarded and condemned by the Supreme Court. So Supreme Court was completely not happy with it, because It's like like filing a false case when the matter is very much clear only that she has got married with her own consent. Why do you want to file a case against the husband, or why are you even like giving that threat to the person? Rather, you go take the statement, close the matter. That is what should have been the approach of the investigating officer in this case. Okay, so Supreme Court said that in its inference would not be required if its interference would not have been required if the investigating officer did his job properly, right? Why did Lakshmi Bai file the case at the first instance? It was because her rights were being violated by the investigating officer. If he would have closed the matter properly based on whatever best he could do, this matter itself would not have taken place. For this reason, it was also suggested that investigating officer must be counseled and programs must be devised to train the police personnel to handle such cases. Now, this part which you see, okay, this is like sort of, you can say, an opinion. Many times you would see that why is this certain thing happening? Because there is less of awareness amongst people. So we need to create awareness. We need to educate people. Like that, a lot many times Supreme Court would provide their opinion as well. Okay, so in this case also Supreme Court said that even if the person is appointed as an investigating officer, he is not having the proper skills or training. There is lack of training which is indicated. So proper programs need to be taken up so that they can be given counseling and they can be given all this training on how to handle such sensitive cases. So Apex Court, they said that, yeah, in many certain cases, it happens that, young kids are going against this established norm of society, and they might want to marry someone from the different caste and stuff also. So otherwise, we are accepting people from different castes for other things. Like we may make friends, we may have neighbors from different castes, but only for marriage thing, we are like so much restricted. So how can we break that, this restriction? It's only by like allowing these sort of marriages. So Supreme Court said that it's completely fine because they both have like married based on their own consent. Okay, so where can a statement be taken? Supreme Court stated that this Lakshmi Bai's marriage certificate and her chat with the investigating officer that she has got married, she cannot travel and everything, in which she said that she is not missing but living with her husband, and voiced concern of her safety in returning to her hometown to record her statement, clearly demonstrate the truth of the issue. So the officer can record the statement wherever the subject feels safe, rather than imposing restrictions that no, you need to come to the police station only to provide statement. Okay, so there is as such no restriction that she has to appear before the police station only. If there are some practical concerns over there, police officer may take that up as well. Okay, so what was the final order in this case? So FIR against this petitioner was ordered to be quashed, and that the present writ petition was disposed of, with the hope that parents of Lakshmi Bai willingly accept her marriage and re-establish their relationship. Definitely on that point, court cannot say that, okay, fine, you accept it. But yes, court can definitely say that you should not be calling this person to her hometown if there is like a risk which she is apprehending and she is not willing to travel there. It's fine. You take her statement wherever it's possible, you record it, and after that you close the matter. There is no point in keeping it open. Okay, so this is nothing but right to choose life partner, right? You are free to choose it. You don't need like approval or consent from your parents. That is what this case is all about. Is it clear?
Yes, ma'am.
Can you tell me what is the difference between these two things? Right to get married and right to choose life partner. What may be the difference? Yeah, marriage, life partner, maybe just cohabitation. Yes, it may be. Like in many cases for live-in relationship, also Supreme Court has said so many things. First one can be by force too, but the second one is freewheeling. So see, when we say right to get married, right, as such, you don't have like a right to get married. If you are choosing a life partner, you decide to get married, you can do it. Okay, you cannot like go to the court and say that I have like a right to get married, give me a person with whom I can get married. All right, but like right to choose like a life partner is a right which you have, that is established in this particular case. Okay, so any one of you, have you seen like an FIR? Anybody? FIR? Marriage, as in say, in many cases it would be said that okay, fine, if you have, like in this one only, right, you have a right to choose life partner. After that, you decide you want to get married, you simply want to continue like a partner, what it is, you can like take a decision. But as such, you cannot go to court that I'm not getting anyone to get married, help me find someone because I have like a right to marriage. If you have got someone who is willing to get married to you, yeah, you can claim for it that okay, fine, I want to get married, like this one, you can do that. Okay, so for FIR, for latest cases. Yeah, for FIR, right, there is like a set format how it will be filed, like this one, if you can see. This is just like a format. Let me show you one if I have. So in FIR, right, it would be filed like in a certain given format only. It is not like, okay, wherever I want, whatever information I'm putting, it would not happen like that. Okay, there would be a set format, in that set format only cases will be filed. I think I should have one FIR. Let me check. Yeah, this is an FIR. Okay, so see, this is how it will be. I have the original copy also. Yeah, so this is how the FIR would like look like. Okay, and mainly, right, for many places you would see FIR being like in a regional language, like in Maharashtra you might see in Marathi, Punjab you would see in Punjabi, but still this would be the format, like district, police station, FIR number and stuff. So even if you cannot read the regional language, ideally like this numbers would be in English only, so you can read that part at least, or you can like get some information. And after this thing is done, right, this details might be written in the regional language. Like in this one, you can see it is written in Hindi with few English words here and there, but usually this is like the format how it is being done. Okay, so this was an FIR which is filed for cruelty, wherein the husband and his family members were not treating the wife properly. So she had filed this FIR, and based on that, there were like cases and everything happened, this entire process. All right, so is this part clear? Any doubts, anyone? Okay, all right, fine then. So we'll end this class here. Thank you, everyone.